You guys are blocking the driveway right now.
Exactly.
Yeah, I'll move once you move. Yeah, I'll move once you move.
You're not allowed to be on their property, and you're not allowed to block.
Yeah, I don't need directives, man.
Sorry?
I don't need directives.
Apparently you do.
No, I don't. That's not a gun. Okay, but there's no need for this response like this. You can come and see without pointing your guns at me. This is ridiculous.
Welcome back to Legal Dissent, where no matter who you are, you have value and you have rights. Thank you for joining us, and as always, if you enjoy our content, please do consider subscribing to the channel, liking this video, and interacting with us in the comments below. If you have videos that you would like us to evaluate, send them our way. All of our contact information is located in the description. We have a ton of exciting videos coming soon that we're just waiting on receiving the body cam footage and other documents from our FOIA requests, so make sure to stay tuned to the channel. Multiple subscribers have requested that we take a look at yesterday's stream of YouTuber Riverside County Accountability, who was filming in Santa Ana, California when he was suddenly stopped by police officers with their guns drawn. He started the stream right as police drove up and did not show the footage from before the police arrived, which raises my spidey senses a little bit and makes me question what was he actually doing before the police showed up. But without any evidence to the contrary, Riverside, and everyone else, is innocent until proven guilty. According to the comments on his video, he was just filming a privately owned business, and they called the police, and that's why they approached him.
I know who you are. For what? That's not a gun. Okay, but there's no need for this response like this. You can come and see without pointing your guns at me. This is ridiculous. All right.
Place your hands on the back of your head. Stop right there. Place your hands on the back of your head and interlock your fingers.
Well, I don't want my thing to fall, man. Hold on.
Look at the stand. Can you just stand it up?
No, it won't. Let me just stand it right here.
Right there. Go ahead and slowly get down to your knees. Lay down. Put your hands out. Cross your ankles and look to your right. Do not move. Do you understand me?
This is ridiculous, man. There's no need for all this. There's no need for you to put all your weight on me, man. What the hell? I'm not resisting or anything. I don't have to question.
Did he refuse to ID himself?
Yeah.
Okay.
So,
let me explain something before you go. You know your rights, man? You're being detained, so therefore you do have to identify yourself.
No, I don't, unless I committed a crime.
That's not exactly true. You're being detained.
I have not committed a crime.
All right. We'll cal ID him at the jail. You're refusing to identify yourself. We need to figure out what you want. Okay, what crime have I committed?
$725 will be in 97 East West First. What did
the comments, please?
The floor for constitutional protection from unreasonable searches and seizures on a national basis is that you are only required to identify if you are detained for criminal activity. To legally detain someone, an officer must have a reasonable, articulable suspicion that you are involved in that criminal activity. Again, that's the national floor of protection. California has 0 statutes that require an individual to identify even if they are detained, and many attorneys agree that you are not required to identify until you are actually arrested for another crime. That being said, California does have an obstruction statute that prohibits people from willfully resisting, delaying, or obstructing an officer in their duty. It's used frequently as a catch-all statute to claim that detained individuals who refuse to identify are obstructing the officer's investigation. At this point, the police officers turn off the live stream, which, in my opinion, is highly suspicious and unprofessional. Without knowing exactly what happened before the footage began, it is impossible for us to objectively say if the officers truly have reasonable, articulable suspicion of a crime in the situation, but based on the limited facts that we do have, the officers have only observed Riverside County Accountability filming on a public sidewalk, which is not illegal or suspicious, and therefore, based on our limited knowledge, this is not a legal stop, and the officers have no right to demand identification. He began a second stream shortly after the first one was terminated, and he is seen collecting the officers' names and badge numbers.
Can I get your name and badge number?
3776.
Name.
Sanchez, 3783.
Can I get your
3024.
Aguilar? 3024? Piece of shit, man. And they ended my stream. That's another one. You guys cut my footage. That's another one right there. Wait for the lawsuit. Wait for the lawsuit. Prime Tech cabinets, you guys. Right here in the city of Santa Ana.
You can be on the sidewalk all you want, just you're not blocking the driveway.
You guys are blocking the driveway right now.
Exactly.
Yeah, I'll move once you move.
So
Yeah, I'll move once you move.
you're not allowed to be on their property, and you're not allowed to block.
Yeah, I don't need directives, man.
Sorry?
I don't need directives.
Apparently you do.
No, I don't.
But it appears this is CPUS.
Copy, time. Ready for that.
I have 8 subjects loitering in the alley, smoking at 14 smoke.
Start calling the station, everybody. Start calling the station. Guns drawn, don't respect your rights right here. I've ran into many officers. They come up to me and just see that it's a taser.
This is when we are able to start piecing together why the officers approached Riverside the way that they did. He was openly carrying a taser, and the officers allegedly thought that the taser might have been a firearm. Open carry is not generally a legal activity in California, and the public possession of firearms is heavily regulated. There are some tasers that do appear to look like handguns from a distance, and it's possible that Riverside's taser could have been one of these models. Based on California law, it may have been reasonable for these officers to believe that they had articulable suspicion of a crime being committed if the taser appeared to be a handgun. What do you think? Should police officers be allowed to detain someone for being suspected of openly carrying a firearm in public? If so, should that ability to detain extend to individuals who are carrying stun guns, replicas, or toys? Let us know in the comments below. And remember that no matter who you are, you have value and you have rights. Don't be afraid to use them, and we'll see you next time right here on Legal Dissent.